Good evening and welcome to the National Press Club, the place where news happens. I'm Tara Kopp, AP Pentagon correspondent and a member of the National Press Club Board of Governors. Tonight's Headliners event is part of our Cocktails and Conversations series, where we take a look at the journalism, legal, and public right-to-know issues that are affecting our work today. And tonight's is a doozy. Tonight we're going to look at the Espionage Act, a powerful and sometimes controversial tool at the government's disposal to try and either intimidate whistleblowers and potentially now go after reporters. The act was originally passed in 1917 to deal with spies and wartime sabotage. It was rarely applied in its first 100 years. That all changed under the Obama and first Trump administrations, when it was repeatedly used to target whistleblowers who were providing classified information to journalists. And there's a new concern that the act may be used even more aggressively now in Trump's second term. In April, Attorney General Pam Bondi reversed a Biden administration policy that protected journalists from subpoenas and from being surveilled. And just last week, our CNN colleagues broke a story about how DIA's early assessment of the B-2 bomber airstrikes in Iran hadn't quite done the damage that the Trump administration said they did. In response, Trump launched a full-throated and personal attack against one of the CNN reporters involved in that story, Natasha Bertrand. And just in the last few days, he's threatened to force all of the reporters involved in that story to disclose their sources. Can he do this? This, of course, is taking place against the backdrop that Trump's own Defense Secretary, Pete Hegseth, has yet to be held accountable for revealing very likely classified information on a Signal chat that involved a reporter. To help us unpack all of this, we're joined tonight by two of the country's most respected legal, First Amendment, and national security lawyers, Abbe Lowell and Mark Zaid. Between them, they have represented high-profile whistleblowers, public officials, and members of the press, often at the intersection of secrecy and speech. Abbe and Mark, thank you so much for being with us tonight for this important conversation.
Thank you for having us.
Definitely.
So, we're going to dive right in, and Mark, I'm going to start with you, because I remember seeing this on X, and it chilled me when I first saw it. So, on March 21st, you posted, "I'm telling you, it's coming. This administration will be the first to prosecute a media outlet or journalist under the Espionage Act. I recommend media outlets stop using individual bylines when publishing national defense classified information." What prompted you to post that?
Well, March, I think, was only like 3 months ago, but they might as well feel like 3 years ago, right? I posted almost the same thing, I think, about 24 hours ago because of what happened with respect to CNN and Trump's comments on Fox News Sunday morning, where he said he was going to compel the journalists to reveal their sources. And then today, Kristi Noem, the Secretary of Homeland Security, went further talking about prosecuting journalists. I think the writing is on the wall that journalists at some point during this administration, we're only 6 months, not even 6 months in, are going to be charged under the Espionage Act for publishing, disseminating, transmitting, possessing national defense or classified information. It may first start with a requirement or an attempt to propel them to reveal a source, and it may then turn into a threat to prosecute. I think, there's a few things as kind of teeing up everything that we're going to be talking about from a historical standpoint, right? This act, as you said, is over a century old. When it was first enacted, it was incredibly broad. It was to prevent individuals, including journalists, from doing or saying anything that was adverse to our or our allies' interests in World War I, right? We're in the middle, for us, the beginning of World War I in 1917. So much so that there was a documentary filmmaker prosecuted who sentenced to 10 years in jail, if I remember correctly, didn't thankfully serve the whole thing, for doing a film on the Revolutionary War, and that was perceived as making the United Kingdom, our ally in World War I, look bad. And that was the reason for the prosecution. Those were all amended in the aftermath of that. The public had an outcry, Congress had an outcry. The statute wasn't amended again until about 1950 and hasn't been amended since. So the key thing for everyone to understand is most of the provisions, and it spans a number of provisions, sections of Title 18, pertain to national defense information. Now, in our modern time, we equate that with classified information. Unless Abbe corrects me, I'm not aware of any case in modern times where someone has been prosecuted when the information wasn't alleged to be classified, but there's no requirement that it be classified. There are provisions within the Espionage Act that do talk about the term classified information, which is a term the executive branch decides, not the judiciary. So that's a key issue. I think the writing is on the wall that this administration, as it is threatened, a lot of things they say you can't believe, but there are some things when it comes to threats that you can believe. If Trump says, we'll do it in 2 weeks, you probably don't have to believe it. But if he says we're going to go after a journalist, I think you should take that really seriously. So the safety precaution for all of you who are journalists would be, look, if you know a story is going to involve classified information, at least your media entity should protect you and say Newsroom, byline source. At least make it a little bit more difficult for the administration to go after the individual journalists. They'd have to go on a fishing expedition to get discovery to find out who the actual writer or reporter might have been, but it's at least one step forward. So yeah, you don't get the byline for the good scoop. Natasha, who I've known for many years, wouldn't get all that credit, but you also wouldn't potentially face prosecution. And that's a good balance for, no credit, no prosecution, credit, prosecution, up to you guys.
Abbe, I know you want to jump in here.
Okay, a couple of things to set the table.
And he's my lawyer, so I'm telling you, you can't disagree with anything I say.
So
okay, no, go ahead.
Let's go backwards a bit, because we all think of this as a phenomenon and as you said, something that is in the Obama and Trump administration. I want to say a couple of things. First is, my first major case that had to do with the Espionage Act was in the Bush administration, when the Bush administration indicted two of the lobbyists for the American-Israeli Public Affairs Committee, and did so for people whose job it was, not dissimilarly to reporters who operated to the right to petition and being involved in First Amendment activities. It was the first time in whatever amount of time that people that alleged their activities to be protected by the First Amendment were indicted under the Espionage Act for the function of providing information to, and you can name it, A, the media, B, to people in the Israeli embassy, C, to other people that did lobbying. That case ultimately didn't get tried because the elaborate process that you get into in these cases, called the Classified Information Protection Act, was a tool that we were able to use to point out, at least at the very least, that the administration used AIPAC when it was convenient for them to disseminate classified information to whoever they wanted, and then on one or two occasions where the government said it wasn't, they were trying to now say, okay, what about the others? Long story short, when we won some of those battles, the government dropped the case. Second historic thing to remind you about how dangerous we could be in. People don't know this very wide and far. In the closing moments of the Clinton administration, in one of those bills like we're seeing, but in the middle of the night kind of bill, which has all kinds of bells and whistles, Congress actually passed an American equivalent of the British Official Secrets Act. And that actually made a crime for the dissemination and included the media as potential subjects. It was only because somebody who was not ready to leave office recognized and was told that this is happening, and he vetoed. And that was the end of it, because somebody stuck it in. And I'm sure that of the 400 and however members of Congress who were involved that night, I'm not even sure that anybody actually knew that that had been stuck in. But that shows you how precarious they are. The last point, to Mark's point, is that Alberto Gonzales, another attorney general, made it very clear that he believed that the Espionage Act covered journalists for the receipt and publication of information, even if they weren't involved in the acquiring of it. And then the last piece that we'll talk about, I'm sure, is the idea of what it takes for a journalist to actually be liable has been something debated and brought into focus by all the events around Julian Assange.
And to add just a couple of points, because to tee up everything else that you might ask, Tara, let's be very clear. The Act applies and criminalizes journalistic activity. There is no
on its face.
On its face. There is no First Amendment defense. There is no shield laws. Those are state shield laws for certain activities about news reporting. Does not apply to national defense or classified information. When I teach this subject, including at Texas A&M, for my bosses
is that
in
a
the
pitch?
audience, yes,
okay.
At the Bush School, I explain there are certain categories, particularly in national defense or national security, where the law, the practice, and the policy are three very different things, or even two or the three are different. The Espionage Act is one of them. The law very clearly criminalizes journalism when it comes to this type of information on its face.
Could I jump in on this point just because one thing that is not bad news, I mean, we're trying to look for silver linings. In that APAC case, representing and putting forward motions of the First Amendment on behalf of people covered, the federal judge who heard the case in Virginia recognized the dilemma of our claim that it was unconstitutional as applied. And his solution is not it was not what we asked for, but it serves as some comfort. He imbued in the statute two intent requirements. There's one intent requirement that applies to everybody, which is that you have intend to disseminate the information. The second that he imposed in order to protect it from the First Amendment, you have to intend the clause that says to cause harm to the United States or to aid an enemy or an adversary. Now, that's not a super thick shield that we all carry around, but it is something. But it is something that, funny that it takes a district court judge in 2013 or 14, 15 to create something that is not in the statute.
The issue was that the policy practice was the policy practice was not to pursue these cases against journalists. Goes back to what your first question was. That has now changed.
Right.
So it's aligning with the law, the practice, the policy. That's where the danger comes to the journalists.
The law was always so broad that there was the potential to use it against journalists, and now very much the reality is that it likely will be used against journalists.
It was always a discretionary decision, and there have been administrations that have started to push it, right? In the Obama administration, in one Espionage Act case, the Associated Press, your employer, there was a subpoena for records without any notice to any of the reporters, and it impacted about 100 or so, as I recall, in the newsroom. And when that became known, the backlash was so significant that the Obama administration issued a new policy to pull back from that. The Biden administration made it even stronger. And now the Trump administration, second, has done away with this. So at least to allow the implementation or pursuit of the law more easily by way of policy or practice. The other thing I'll just throw out, and this is a very common statement made, particularly from journalists and a lot of my whistleblower advocate colleagues, the notion that the Obama administration punished, factually is true, more leakers than any administration previously. One, I would challenge that all of them were whistleblowers. You can't be a lawful whistleblower with respect to disseminating classified information. And this is something we do at Whistleblower Aid to make sure they do it lawfully. So that's the first thing. But the second thing is, and I actually, although Abbe is older than I am, point that out. I actually worked on Espionage Act cases in the 90s. And the administration rarely could catch a leaker because it was just, this is pre-computers, or at least pre-internet, I should say. It was very difficult from an evidentiary standpoint to find out who the person was. When the internet came into full force, especially in the early 2000s, those who leaked and the reporters were not careful enough to protect their trail, and the evidence became a lot easier for the government to capture and then prosecute the individuals. The Clinton administration would have loved to prosecute leakers. They just couldn't catch them. Obama could.
So let me ask a question. Why wasn't the Espionage Act used in the Pentagon Papers case against the New York Times? Is it because of the difficulty of capturing the leak, or what was your thoughts on that?
Well, remember that it was close. That in the Supreme Court's decision, there were a number of justices not in the holding that indicated, it was 4, that could say it applies. Why it wasn't? Because we lived in a different time with different norms, protections, and assumptions that you wouldn't go after a reporter. So that's one reason. Remember when we talk about the Espionage Act, and I don't know where you want to go and I don't want to monopolize your questions, but I do want to point out something that's just bizarre about it. Remember, this is an act, as you've been hearing, that was passed for the purposes of preventing what? Espionage. And it's being used more frequently, well, it's used for that, for sure, but it's become the Non-Disclosure Leaking Act.
Yeah.
And with the same penalties, like the same massive amounts of penalties, including 25 years and possibility. That's one aspect about it. And the last thing to say about the Obama point, you can go to cocktail parties and be the hit when you ask people the question, under what administration has there been more investigations and prosecutions under the Espionage Act for non-spies than any other? And people will say Nixon, and people will say whatever, and then you'll say, no, it was Barack Obama. And I have a reason why I believe that happened, but I don't know if that's interesting.
So I want to bring it to present day and what we've seen in the last week and what we've seen in the last couple days from the president. If you were advising the CNN, the New York Times, the Washington Post, and I don't know if you are right now, so we can just keep it in the hypothetical realm, what do they do right now? And do you think that the Espionage Act would be applied by the administration?
Well, Mark gave an interesting prophylactic measure, right? I mean, it's one layer, as he said it. It won't take them hard to know that if the same people that use their bylines, but they cover the Pentagon, and the leak comes out of the Pentagon, they might actually knock on your door and say, wasn't that you? It is a layer. So that's one thing to do. I'll tell you the next thing to do is you have to be more careful. One of the things that happened in the Kim case, and this was something that created a lot of uproar, was journalists were having their cell phone records subpoenaed from their carriers or their internet service providers like, Google, et cetera, which itself, by the way, was unheard of before that because now everybody understands that this administration will do it. That puts reporters on guard as to how they're going to communicate. Do I think that some of the apps are probably better than others? I don't know if they're impervious, but that's certainly something. I don't think you'd use a traditional email address to talk to your sources that are in the government that are your sources for that which might be national defense information. So there's that. I also think that what people carry around and how they carry it around is something to consider. But let me say that the most important protection will be the vigorous and aggressive protection of people who serve as our journalists and embody the First Amendment in the courts of law, and make sure that wherever it's done, we at least use that guardrail as it still exists.
Mark, how do you think the administration might try to apply the Espionage Act if they do take that route to go after any of these journalists?
Hard to predict what they will do, because particularly they seem to, very much they spur on a moment, right? It'll depend on what the story is, how embarrassed they feel, who feels embarrassed by ordering it. I imagine, and I would at least hope in the nature of if they are going to pursue this, they'll do it incrementally. It will first be, they'll subpoena the phone records of the providers, which the policy now allows. And in fact, that is part of how folks have been caught over the years. Tom Drake, when he provided information, and there's certainly a debate as to whether it was classified, to a reporter at the Baltimore Sun, he used hush mail. Hush mail as an encrypted communication, I won't say app, I guess email at the time. But it didn't help that hush mail was based, I don't know who owns hush mail anymore, if it even exists. It was based in the United States. So they just served a subpoena on the company to get access to the actual emails. They didn't have to break any encryption. The other aspect would obviously be, and the policy sets forth that they're supposed to talk to the journalist or the company to ask, would you provide the information over willingly? I doubt many, if any, will. And there are steps to be taken. There are notice requirements. As I recall, it's supposed to be 45 days that they then have an ability to respond, and they can go, they talk about how they're going to be in court. You know, I'll put it this way that I always tell my journalist clients and any of my clients inside the US government: you do not want to be on the receiving end of an Espionage Act prosecution. It is not a fun thing, and you have a very good chance of, likely, I already have one journalist client, he's made it very public. He's like, I'm going to jail. I've gone to jail before to protect my sources. I'll go to jail again. And you know, Judith Miller did that back in the Scooter Libby case until Libby waived his privilege with her, I think for like 60 days. It's going to be, I hope, these incremental steps, but it's going to be a very precarious situation, and I think some journalists are going to have to be prepared to serve some time, if not on principle.
Here's another protection journalists can think about, I think. My fear, among others, is that sliver in the Supreme Court's decision, which is not an Espionage Act case, it's the Barnicki case, about whether a journalist, a publication, can be free to publish that which it is provided, even if that material was stolen or improperly obtained. A really important case in a different context, but it's applied in this way. And then, as I said before, what the investigation of Julian Assange opened up. I am worried that the government has a better way not to be yelled and screamed at as being invaders of the First Amendment when they have the ability to allege that a journalist has been in cahoots with a person providing the information to advise them as to how to do it, which, back to the Pentagon Papers, might have been a hook. So if journalists are being very careful with their sources, they're going to have to be pristine about not being seen, heard, emailed, texted in any way that could be alleged to be part of the theft with which to begin.
Yeah, it's like going back to Deep Throat, right? Meeting in a parking garage. And now, what didn't they have at that time in 1971, 72? They didn't have all the cell phones that all of you have, which are probably, maybe, hopefully they're silenced, but they're on. So everybody know, you know, the phone companies know where you are by where you're pinging on the towers. And that is another thing that can be, look,
and not only that, I'm sorry to interrupt, but you just remind me, again, in the Stephen Kim case.
I was going to say, how was it that your client and James Rosen of Fox News got caught?
For all of you that have desks at government buildings in which you're supposed to come in and out, don't forget that your fobs, or whatever they're called, or your ID cards, are kept as to when you've been in and out. They took Stephen's traffic of ins and outs, and they took James Rosen's, and it wasn't a surprise that they tended to be coming and going into the building at weird hours that are not 9 in the morning at 6 at night at the same time. So there you are.
And if I recall, your client was on his computer looking at one of the classified documents at the same time the phone records reflected he was on the phone with the reporter.
True point.
Not good OPSEC.
So how does Signal fit into this? Because a lot of us now have disappearing messages. Some of us have instantaneous disappearing messages. Can the government somehow subpoena and still get those messages?
No, for Signal, they don't exist. So I hate that because I can't remember what the heck somebody sent me 3 days ago, and I haven't looked at it yet, and it's gone by the time I look at it. But the safety is for Signal. There is no way. Those are not somewhere like if you delete an email and you could still retrieve it or your photo from your computer. It is gone, which Hegseth is breathing a sigh of relief on some aspects of it.
Yeah, but he was probably not bright enough to know that you could make those disappear in an hour, and it wasn't until it got exposed that there was that window where you could have found them. But I guess that, yeah.
But right now, that would, if you're going to communicate via that is the safest way. I will say some federal agencies have a policy that their employees are not allowed, even on their personal devices, to have an app like Signal for the purpose of preventing that type of communication.
But you also have to worry that whoever you're communicating with might be taking screenshots.
Correct.
Yes.
And also have not put it on the same disappearing frequency as you are as well. So it's not fail-safe,
No.
but it's a lot better than the surveillance camera at the garage for Deep Throat. Oh, there wasn't one, I'm sorry.
All right.
So let's get back to some just practical, what's going on in newsrooms today. If you're a reporter working on a national defense classified information story today, what sort of conversations do you need to be having with your editors, and what do they need to be having with you?
Well, I don't know, let's start with it.
Yeah.
So we've talked about some of it, right? I mean, I think the MO of reporters in general, I don't think this is just a national security issue. I think the MO of reporters have to be better calibrated in the modus operandi of what they do and how they do it, in terms of how they treat a source and what apps they use and all that. I think editors have always been, back to the famous documentaries and movies about Kate Grant and doing, okay, what are we going to do with this material, be as scrutinizing as to source, methodology as they always would be, but maybe more so in the national security field. Third is, I think this is not supposed to be self-serving, I promise, but you're going to have to get attorneys involved in the process a little bit earlier than you might as well. It'd be better on the prophylactic side than when the subpoena comes, I think. And you know, most media organizations have internal lawyers that are well versed in this area, so I think that's important. And I think fourth is you have to have publishers and editors who understand the peril that we are in and are willing to make the legal fight. I mean, we have corporate media owners based on the profit motive who may be less protective of the First Amendment of their subsidiaries that broadcast the news for business purposes. That is a worrisome event when you had no doubt that in the good night and good luck era, CBS wouldn't kowtow to a bad defamation suit.
So another development in newsrooms over the last 20 years is they've hired a lot of military veterans, people who had experience in Iraq, Afghanistan. A lot of those soldiers, airmen, et cetera, had clearances in the past. Does that make them more at risk if they're involved in national security reporting? Can that old clearance come back to haunt them?
I fielded this question even recently because some of the people are more in tune with these types of concerns. And that's a real issue, and it's an issue from a standpoint of pre-publication review. If you have what's called SCI access, sensitive compartmented information, you'll hear it in the TS-SCI, top secret SCI. There are different non-disclosure secrecy agreements that we sign when we get access to classified information. For secret and top secret, which are called collateral, we sign an SF-312 generally, and there are some other documents inside of agencies. You can Google these, find these documents online. It's a very straightforward. You're not allowed to publish, disseminate to unauthorized people classified information, but there's no pre-publication review requirement. On SCI, which is the SF, I don't know if it's an SF, but it's 4414 document. SCI information has a pre-publication review clause, mandatory in perpetuity. This is what grabbed Frank Snepp back in 1979, 1980, who went on to become a journalist at NBC, as I recall, I think. Could be ABC, so I'm not sure which. Television journalist in Los Angeles. And the question would be, if you report, let's say you worked in the military and you worked on Russian issues, and because of your background, you get hired to be a reporter to write on Russian issues. If you had SCI, every story you write, at least on paper, would be required to go through pre-publication review. No reporter is going to do that. No editor is going to allow that. But it does give a mechanism for the government against that reporter to go after them for a civil lawsuit, a breach of contract. Doesn't even have to threaten criminal penalties. There doesn't have to be anything classified or national defense information in the article. It's the fact you didn't publish you didn't review it, pre-pub review it before publication. So my advice for anyone for that was, again, sort of, you know what, you got to kind of bite the bullet and not get the credit if you're going to work on those stories. Let someone else in the office take the byline if you're going to do that, because the risk in this administration is too great. In
And take
prior
that to its
administrations,
illogical conclusion.
I wouldn't
So
care.
This is traditionally what happens when you write a book or you write a long article and it's written.
Yeah.
Taking it to its illogical conclusion, if you have one of those consultants sitting there on, CNN or MSNBC or Fox and is talking about the raid that just happened in Iran and is about to say something out loud, how do you pre-screen and pre-approval that? So again, that would be a norm that nobody would cross over in the real world unless it was blatant, although I don't know that anything more blatant than the Secretary of Defense and the National Security Advisor saying what's about to happen in a military operation within minutes. But putting that one aside, it does seem to me that if you take it to its illogical conclusion, you have this issue about the oral dissemination of news that implicates that.
The policies, written policies, absolutely speak and include oral presentations. And there are always, every few years, there would be a news article in the Washington Post over some former CIA case officer who had retired years before and had become a talking head on some network, and they'd get a letter in the mail threatening, you better watch out, we're going to come after you. The government has never gone after anyone to date, other than in World War II once.
But hold your thought, because one of the first clients of my nascent new law firm was Miles Taylor, who was a DHS official in the first Trump administration and a willing and supportive member of the goals of that administration when it first went into office. Didn't turn out that way. And then wrote that book as anonymous as to what was wrong with the way the government was dealing with issues at DHS. And then he became disclosed as to who he was and became a very strong critic. And one of the first executive orders of this president was to issue one against him and another of his colleagues, seeking an examination of whether or not he did violate his pre-review period and to start a criminal investigation of him. So who knows?
We've talked a lot about protections for the reporters. What about protecting the sources that are working with us? Is there a difference in whistleblowing and espionage in this administration? Is there a difference in protections?
There's no difference in what the protections are. I think there's likely going to be a difference in how serious the administration credits those protections. There are mechanisms to be a lawful whistleblower with unclassified information to give it to the media, as long as it's not in violation of statute. There was a case, Robert McLean, went up to the United States Supreme Court about the air marshals, and he provided information. And the court ruled there wasn't anything that violated the law in providing this unclassified info, so he couldn't be retaliated against under the Whistleblower Protection Act. Again, for classified or national defense information, which could be almost anything that the government says that it wants it to be, there is no allowance under the whistleblower laws to provide to the media. Now, how can they be whistleblowers? They can go to the inspector generals, they can go to authorized members of Congress, the intelligence committees. There's mechanisms that we've created and pursued, especially through Whistleblower Aid, that I helped co-found in 2017, to allow for that.
But let's point out that that system that has classified information whistleblowing procedures doesn't allow immediacy to the media, of course, makes sense to some extent, does require the person to go up the chain, as it's called, which would include a superior in the office, but then, as Mark says,
doesn't have to.
The inspector general, and then also, or sideways to Congress. That works if you have real inspectors general and if you have members of Congress who aren't going to lie down in the same vein as the administration taking these actions, which is another example of our founders' brilliance in trying to make sure that there were separation of powers and checks and balances, and one, in some ways, party doing it. But if all that breaks down, the classified information whistleblower procedures are meaningless.
Now, One other way, and I don't think, this kind of happens, but I doubt it's written anywhere or most would acknowledge it. Another way would be for journalists to work with members of Congress if they are given classified information to give it over to members of Congress who can lawfully have it. They might not be able to physically possess it depending on what committee they're on or in their personal office, because they might not have a safe that is authorized by the GSA, which General Services Administration, am I getting the acronym right? That decides that, if I'm getting my agency right. But work a deal with the member of, they can have first dibs on what story. Members of Congress, as we found out in the Pentagon Papers case, with Senator Gravel from Alaska, who's now passed away not too long ago, it is legal for a member of Congress on the floor of the House or Senate to read classified information into the record. Do they do that? No, of course they don't. They could be censured, they can be kicked out of Congress, but they can't be criminally prosecuted. We thought most recently, I think, that was going to happen about the torture papers, that one of the members, as he was retiring, that he would do it, but he did not do that.
One more protection area, because I am continuing to try to find the brass ring at the end of the rain. I'm mixing metaphors. The gold at the end of the rainbow. Something Mark said before I don't want people to pass over. The Act in its most teeth and its most severe requirements, restrictions, and penalties is the non-authorized disclosure to a person not allowed to get it for what's called national defense information. To be NDI, it likely almost always has to be classified, but not all classified information is NDI. The leg of NDI that provides some basis for a defense of journalists and everybody else is classified and closely held. And in the day of the internet, I mean, in one of the cases we and my colleagues did, we were able to show, as would not be a shock to you all, that almost everything that was substantively in the classified information you could find in open source. So it wasn't necessarily, quote, closely held. Where the rubber meets the road are the cases, and that makes sense. It's not so much the substance, it's how did the government come about getting it, its sources and methods. So the example that I and others always give is, tomorrow one of you could publish that yesterday Kim Jong-un ate a tuna fish sandwich. There's nothing classified about the fact that he ate a tuna fish sandwich, but how do we know he ate a tuna fish sandwich? So that's the source and methods issue, but still in NDI, it's a sliver of a defense.
I want to expand on the clearance issue just a little bit because of something that Pentagon reporters are currently facing. To have our hard pass to get into the building, we used to just have to sign a sheet of paper that was basically about the parking pass, about access. You're not going to try and go into a skiff, et cetera. But we are now waiting on new regs that might include language on an obligation to protect sensitive or classified information.
In order to get access?
In order to get that hard pass. And so I'm wondering, this seems like an expansion, and I'm just wondering if that is pursued, it would be unprecedented, but could it be legal?
Well, I mean, it's, quote, legal until somebody challenges it under a theory. The theory would have to be that in some way it inhibits your First Amendment right to do your job if they put bells, whistles, conditions on your getting access to the building. I don't know, I have to think about that one for a little bit more. But what it does do is put you in the same position as the government employee who signs a confidentiality agreement, which is one of the elements by which people are prosecuted for having violated. I don't know, the ability to require a reporter to affirm that she, he, or they will guard. I don't know what the verbiage is.
Well, we haven't seen the language,
Yeah.
so we
I'd
don't
have
know
to
what
see
it's
the
gonna-
verbs.
Yeah, I know. So the terminology of sensitive was introduced, I think, in April with respect to the new policies at the Justice Department, and not quite clear what sensitive means. We have sensitive but unclassified SBU. We have controlled unclassified information. There are different categories and caveats, designations of information that have different penalties attached to them, some of which don't apply to us outside of the sphere of government, but otherwise could be subjecting someone to disciplinary action inside the government. But some of it has to deal with, look, I remember in the mid-90s, I could just walk into anybody, you walk into the Pentagon and wander around. I remember being lost looking for the Defense Intelligence Agency's General Counsel's office because they have no signs anywhere, and there was nothing, there was no
And every
artwork
hallway
on the wall.
in the Pentagon is the same.
State Department too, which at least had tape on the floor, different colors, so you knew which color to follow. Now, none of us can do that unless you have permission to get into the building, and most of that was Oklahoma City and 9/11 that created those security requirements. Your current employer is, I believe, was one of the entities who sued about being blocked from the White House. And the decision, as I recall so far, was certain aspects of the White House, no, that's interfering with your job and not permitted. But other aspects of the White House, they could block. Journalists in general, wasn't just AP. It does sort of impose an interesting new framework that I would say sounds equivalent or analogous to pre-publication review, where they might create a contractual obligation on the part of journalists so they don't have to worry about going after you for Espionage Act. They can go at the low-hanging fruit of saying you violated your agreement and we're going to maybe prosecute or at least sue you for a breach of contract, and here's damages, and that could have an intimidation deterrent factor against journalists.
As I'm hearing both of you speak, ideas are coming into my head as to how you could challenge such a policy or regulation when applied to journalists. It would be subject to challenge now. Subject to challenge in an unprecedented area of the law that's never been tested before will depend on what judge hears that to begin with and what appellate court then reviews it, et cetera. But there's definitely grounds by which you could challenge such a regulation as an improper impingement on the exercise of the First Amendment.
I'm going to read a couple of the audience questions. Can the Espionage Act prosecutions be made against non-U.S. citizens?
Of course.
Of course.
I mean, again, it's been charged that way. The question is, can you bring that person into the United States? If somebody who has just wreaked havoc on the U.S. from Russia or someplace is not going to be extraditable, but yes, it certainly on its face applies.
And this was going to be one of my later questions, but why has it been so difficult to amend the Espionage Act?
Well, Congress doesn't work, for one, right? But I actually take the position, I do not want Congress going anywhere
close
near
to the Espionage
Act. For one thing, they're going to screw it up. Even if you, and there's a couple of different problems. One, I'm concerned that they'll make it worse, especially in the current climate. But the reality is, very few cases are prosecuted under the Espionage Act, statistically speaking. There are countless referrals from agencies, criminal referrals to the Justice Department of perceived leaks. Just pick up the Washington Post, the New York Times, the Wall Street Journal. Constant leaks, mostly probably verbal, many of which are authorized in the sense that it's the executive branch deliberately giving it because it feeds a narrative. That goes on in every administration. But
Did I say that in the did I say that in the waning moments of the Clinton administration, in the middle of the night, the United States Congress passed something that was called the Official Secrets Act? I'm going to trust that body with trying to mess around with the right balance between the First Amendment and national security, as much as we'd want it to be. I mean, that act should not cover both people that are trying to destroy the United States as spies and those people who are reporting the news. Right now, it's the same.
It's sort of like the difference between a car crash and a plane crash, right? How many, 60,000 people die every year in car crashes, but it's one person, two people, over there, you don't hear about it. One plane crashes with 200 people, big news. Same thing with Espionage Act prosecutions. Big news every time, very few instances. If it's amended, it will actually cause so much havoc in the courtrooms because every change of language can now be litigated by both the government and the defense counsel as to what does it mean. And it may get interpreted to mean something different than what Congress intended it to be.
Two examples of that. Again, because we don't know who is going to try to amend it to make it tougher or to make it less tough, but two examples of trying to make it fairer. There's always been a point of, for example, a defendant cannot challenge a defendant's indictment by arguing that the information shouldn't have been classified to begin with. For example, I mean, there's so many people who classify information on the planet Earth. It's also something that most people don't understand, how easy it is to classify information. You have all these people who have that right. So you're one of those people and you've been working all day at your desk. It's 5 o'clock, you want to leave. And you have a document and you have to decide its classification. You could decide it's unclassified and then it comes out someday and people want to know what the heck did you do? Or you could just put the top secret stamp on it from your little desk stamp machine and then you're protected from doing that. So there was one issue about whether that could be a defense. The other defense was what people refer to the Ed Snowden defense.
The public interest defense.
If you can show that what you did by showing that the United States government was tapping into every phone of every American was something that was in the public interest, going to possible defense. But that's only if those kinds of things are added. What if there's an explicit point about how it allows the subpoena or summonsing of members of Congress, members of the journalism. So the reason it's so hard is because there's never a consensus. There's a consensus that it's goofy, but there's not a consensus as to whether you'd make it harder or easier. And I think that's one of the reasons.
One of the things we haven't really talked about is just the impact of the Bondi memo that came out earlier this year, where it wasn't just classified information, but as you said, sensitive, but as my AP reporter or AP colleagues reported, information that could hamper the president's agenda. Very, very broad.
I think we're going to be indicted.
Or your security clearance is being revoked because it's not in the, quote, national interest, end quote, for you to have one. So you want to start with the Bondi memo?
Who knows what that means? I mean, look, it's a real problem. And that goes to a lot of how much was in the discretionary authority of administrations, particularly the executive branch. And it's amazing now when you see what's happening now and you think back of how much discretion actually the administrations that you hated the most, regardless of Democrat or Republican, that you yearn for so much more now, because they made decisions that this would not even cross their mind. In the worst of the worst administrations, in our lifetime, going back to, say, to World War II, where espionage was a real threat, and any interactions with being a German going to the Madison Square Garden and rallying against them, or for them, I should say, or in the Nixon administration or the Clinton or the Bush administration, where it's like, I wish John Ashcroft and Dick Cheney was actually back in power now, because they didn't go this far. Look, we're gonna have to see. We're only 6 years into the first 4 years of this administration, so.
I mean, but to underscore that point, this is not just true in the area we're talking about today. In terms of virtually everything that we're reading about or wondering about, in some cases challenging in courts, the difference is that what was given as the norm of the way something works, what a president says, what a president doesn't say, what a president acts and doesn't act, what the people around him are willing to do, whether Congress will allow something to happen. All the norms that we have just heard Mark talk about other administrations that wouldn't even go there, wouldn't even think about it, their expression in wrestling is what? No holds barred.
We actually litigated in the first Trump administration under the Freedom of Information Act, where I represent a lot of journalists. We litigated whether or not Trump's statements or tweets served to declassify information. And the courts generally ruled, if not exclusively ruled, no, it does not, because we can't necessarily believe what the president was saying.
So I want to talk about defense of journalists present day and going forward into the next couple of years, and particularly you, Mark, if you could talk about how has the loss of your clearance affected your ability maybe to defend?
We say temporary loss of his
Temporary
clearance,
loss.
please. Thank you very much.
I'll ask my lawyer, am I allowed
Yes,
to
let's
discuss
ask the lawyer.
my case? Let me put it in this way. So one, journalists have been targeted before by the federal government. In one of the Espionage Act cases that I worked on for Jeff Sterling, who was a CIA case officer, prosecuted and convicted of providing classified information or national defense information to the New York Times, to Jim Risen. Jim Risen was subpoenaed. And that delayed the case, actually, for a number of years because the New York Times litigated that, enforcing him to disclose his source. And it went up. He lost at the district court, and he lost at the Fourth Circuit, and the Supreme Court denied cert. Effectively, that means, right, the Fourth Circuit decision was in play, and he could have been compelled to turn over his source or face contempt and go to jail. The government, which would have been the Bush administration, no, Obama. Obama, I'm thinking what year it was. Obama, 2010. The Justice Department and the Obama administration put him on the stand with the understanding they weren't going to ask him who his source was. They, in the same way that I got subpoenaed as a grand jury witness in my own client's case, only was discussing non-privileged information. So they had phone records from Jeff Sterling to Jim Rising, but they didn't have the contents. And they argued what the government thought the contents were, and that was sufficient, which I disagree, to even circumstantially prove, because the jury convicted, unfortunately, Jeff for that action. My clearance, it doesn't impact me in the sense of representing journalists, because they're not supposed to have classified information in the first place. But
I didn't make that argument on Friday. I should have thought about that.
But look, it does impact me in Jeff's case. I protected him as his legal counsel with the FBI and the CIA when he was being interviewed back in like 2003, I think it was. In fact, the FBI fought with the CIA because the CIA would not increase my clearance level to SCI, and the FBI did so on its own, or threatened them that if they don't, they'll just exclude the CIA. So I cannot defend individuals who are facing these investigations if the information is classified, whereas otherwise that's what I've been doing for the last 30 years almost.
We're in kind of our final minutes, but Abbe, first, what were your thoughts?
Well, your question had two parts. The first part was how to defend journalists, and the second part is how does it impact somebody like Mark, who's made a career of being a star in doing so. I go back to the precautionary things that Mark and I have said that people need to be thinking about. And I go back to the thing I thought about, that I've said, which is it's not as dismal from the idea of protecting the journalist in court as it is to get the means by which you might be hauled into court, if you understand the difference. The First Amendment still exists. I am very optimistic that there are district court judges around the United States that understand the parameters. I also believe that there are judges on the Court of Appeals, and I am going to hold on to the hope, because of the language of other Supreme Court decisions, that even among this 9 justices, I can think of 2 or 3 that would probably think the First Amendment was a bad idea to begin with. But I can think of 5 or 6 that in the right case will understand the parameters of the press doing its job, protected by the First Amendment. It'll be very fact-specific, it will be context-specific, and I can't make a blanket prediction. But I have to sit here as a lawyer thinking that all is not lost.
I'm so glad you said that, because this has been a pretty dark conversation, particularly I think for all the reporters that might be out there thinking about the documents that they may be obtaining or the sources they may be talking to. So I'm really grateful that, in your words, keep pressing on.
For sure that. I mean, last point, I've said this, people who know me know that I've probably worn this phrase out. The founders had an amazingly brilliant idea. It's one of my favorite parts of history. And everybody knows the first part, and you guys know the second part. The first part is they thought of the separation of powers, checks and balances, 3 co-equal branches. They had 2 others that were intrinsic to our country from the beginning. The first was the 4th estate as being the 4th protection of the rule of law, and the 5th are people like Mark Zaid, the lawyers that have done this for all of their careers as the 5th protection. And so those exist in some ways or another. When one fails, hopefully the second does. The worst thing that I worry about now is the efforts to, strip away the power of the press, strip away lawyers that we've seen happening when the other three branches aren't operating the way we should.
There was a reason why in Henry VI, Shakespeare said, kill all the lawyers and not kill all the journalists. It was as much as I don't know how much the Fourth Estate existed in 1560 or so when it was written, give or take. But the notion of killing all the lawyers, which Dick the Butcher said, and that's why I call Trump the Butcher, it's not an insult to lawyers. It's actually a compliment. They wanted to kill all the lawyers because the lawyers were going to stop the coup of taking over in an authoritarian way the government from the king. And it's the journalists, as Abbe said, and the lawyers, the judges, who are going to make the difference to ensure the rule of law is upheld for at least as long as we can.
Well, before my final comments and final question, I just want to take a moment to thank the Headliners Chair, Jen Judson, and her team, as well as Club Executive Director Didier Sauy and his staff for making tonight possible. Thank you to the audience. This is a great showing and a very active live stream. We hope that you'll all be at our next Headliners event, which is Tuesday, July 8th, where David Rubenstein will be talking about his most recent book on his philanthropy and career spanning from the Carlyle Group to the Baltimore Orioles. And personally, both Abbe and Mark, I just want to thank you as a journalist and on behalf of all of our colleagues for everything that you're doing, not only for freedom of information, but to help protect journalists in doing their jobs.
Thank you.
And with that, you can't have a proper thank you without a National Press
Yeah, of
Club
course.
hug.
That's great. Thank you. And thank you
Thank
for
you.
you, and thank you for the club to let us have this conversation.
Yeah.
It couldn't be more important.
And thank you for everyone coming out in the heat or the rain, depending on when you walked outside.
And that concludes our discussion.
And the bar is
tonight. And
open.
the bar is open.